Today, we'll be discussing how to manage the external investigator. You've received a complaint of harassment, and you've determined that you need to retain an external investigator to help you resolve that conflict. And you expect that person to be an expert. They're supposed to come in and bring a sense of certainty to the situation and give you a sense of clarity. But oftentimes, that person comes in and they bring confusion. They are, after they've been hired, they're off conducting interviews, and you're not really sure, who they're meeting with and why. You are completely in the dark. And the only time that you hear from this individual is at the end of the month when you receive their invoice. We are going to give you some tools today to help you keep your investigations on track, help you to get timely advice and information from the investigator, and keep the investigation on budget. My name is Dorian Persaud. I am the senior lawyer at Persaud Employment Law. We are a team of lawyers who specialize in conducting workplace investigations and helping you to create healthy workplaces through investigations, training, and proactive advice. Let's start first by looking at the duty to investigate and why you need to conduct an investigation in the first place. We have legislation at the federal level and in all provinces that indicate when you receive a complaint of harassment, sexual harassment, or violence, that you need to take steps to look into that concern. And those steps have to be appropriate based on the circumstances. And even before we had these statutory obligations, human rights tribunals required employers to conduct an investigation where there was an allegation of discrimination. And in fact, the tribunal would often award damages against an employer where, even though there was actually no discrimination had occurred, the employer didn't take the complaint seriously and look into it. And for that reason, the tribunal said, look, if you don't at least do some sort of a fact finding and go through that vetting process, that, these protected grounds in human rights legislation really aren't protected at all. So you need to go through the steps to make sure that someone's human rights aren't being violated. And it's important to keep in mind here that even without a complaint, if you as an employer are aware of problematic behavior in the workplace, let's just say no one's complained, but there is an inappropriate relationship going on, consensual relationship between a manager and his or her subordinate, that's something that you need to take steps to look into and address in the appropriate way. Because if and when that relationship goes south and there's a fallout, you as the employer are ultimately the one that's going to be held liable for not maintaining a workplace that was free of harassment and not ensuring that the broader workforce was able to work in an environment that wasn't influenced by that toxic relationship that just came apart. When you make that decision then to bring in an external investigator, you're in that role of providing oversight. And you want to be careful here of providing oversight and not interference. You don't want to take any steps that are going to tip the scales on this investigation, so to speak. And let me give you some examples of that. So reasonable oversight is asking the investigator, who do you need to meet with? And asking questions in terms of why you need to meet with certain individuals. It may be the case that you can accomplish the same thing by meeting with, 2 or 3 of these folks as opposed to all 5. And that's a valid question for you as the HR professional who is overseeing this process. It's fine to have those questions. It's fine to ask those questions and make sure that the investigator is able to give you an answer that satisfies you. What you don't want to do is interfere with an investigation. I've had cases where the HR person wasn't forthcoming with information, didn't want to share information that was relevant to the investigation that existed, within the company's database, was coaching the responding party in terms of how they should prepare for and approach an interview with the investigators. Things like that are, putting your thumb on the scales, right? And really tipping it in favor of one party and ultimately affecting the integrity of the investigation. One question that I often get asked on this point is, Dorian, how much information should we share with the investigator? Being in HR, you have knowledge of the whole history of the relationship, but as far as this person's work at the organization is concerned, you've got much more background information than the investigator who is stepping in and meeting these parties for the first time. And this individual who's now filed a complaint may have been part of 3 or 4 investigations in the past. And you might be sitting there with questions as to, well, how much of this do I need to share with the investigator? And oftentimes, the investigator doesn't need that background in order to do his or her job. Oftentimes, in the vast majority of cases, you would receive the complaint and start with a fresh investigation without the need for that background. But there are cases where that background is helpful. And let me give you an example of that. I conducted an investigation on behalf of a hospital where a technician was accused of inappropriately touching patients. And his job didn't have anything to do with touching or examining the patient. And in the course of the investigation, it turns out that similar complaints of this nature had been filed in the past. And we struggled with, to what extent do we want to know about those other complaints? And to what extent do we want to rely on them and put these allegations to the responding party? And we determined ultimately that the behavior in the past was so similar to what we're dealing with currently in terms of his behavior with these patients and how he was touching them and where he was touching them. And he had been cautioned about that conduct in the past and was made aware that this is inappropriate. You're not to do this, and this is how you are to do your job. And it was surprising then that these behaviors are occurring again. So we made the decision to, both collect details from those previous investigations that HR had conducted. We reviewed that evidence and we put these allegations to the responding party to have him explain how is it that these things happened in the past, that you were told in no uncertain terms what the expectations were, and yet here we are a couple years later dealing with the same behaviors. And he didn't handle that situation well. We ended up making a finding against him, and the evidence was there to support that finding. And so I want to insert a note of caution here. I'm not saying that you're relying on how someone has behaved in the past to make a finding that they did or did not do something in the current circumstance. But there are cases where the investigator can benefit from that historical information. So if you're retaining someone who is good at what they do and they know the rules of evidence, you can have the confidence to rely on that investigator and to say, look, there is a backstory here. How much of this do you want me to tell you? And the investigator can help you to make that decision and can help you in terms of what information he might need now at the front end of the investigation. And there may be other documents or other information you have that is more appropriate to be shared on the back end of the investigation after the investigator has met with witnesses and obtained the information that he needs to firsthand. After that, going through that process and wrestling with the evidence himself, maybe there's an opportunity there to review this historical information in terms of relying on that, either in the current report or maybe in the recommendations or other aspects of the work that flow from the mandate. One of the most common reason why investigations go off the rails is because the parties from the very beginning are not clear on their mandate. It's not clear from the very beginning what it is the investigator is hired to do. And when you don't have clarity from the beginning and you don't have a roadmap to direct you in terms of, here's where we're going, you end up going in many different directions and ultimately not satisfying your mandate and causing a train wreck in the process. So as HR professionals, you want to make sure that when you're bringing on an investigator, that you're very clear with that individual about what it is that they are being retained to do. And as we all know, things evolve in the course of an investigation. There is, more evidence that comes to light, and maybe there are more parties that come forward and say, "Hey, we also want to file a complaint against this responding party." And if the investigator is clear on his mandate, he's not just going to be running off and looking into all of these interesting issues that have come up as far as potential misconduct in the workplace. He's not just going to go run off and start investigating these new complaints because they just came forward and were disclosed to him during his investigation interviews. He's going to come back to you as the client and say, "Look, here's my mandate. Here's other information that's come up that may change my mandate. How would you like to handle this?" And you can have a discussion and make a decision in terms of, do you want to expand the scope of the mandate? What do you want to do with these new allegations and potential complaints that have come forward? And again, you can make sure that there's an order and a system to the work that's being done, and along with that comes a predictable timeline for completion. Once you have the mandate narrowed down, that information in terms of what it is that the investigator is being hired to do, that needs to go into the retainer agreement. And that's simply the written contract between the parties that says, here's what we as an organization are hiring you, the investigator, to do. And it spells out the obligations that the parties have to each other. And one of the things that will be spelled out in there is, along with investigating these complaints, do you want the investigator to provide you with legal advice? Do you want more often than not, the investigator is being hired to provide a finding of fact. So we want you to look into this allegation of harassment and let us know, did these behaviors occur or not? And to the extent that they did, does that constitute a violation of our workplace policies or any applicable statute? And that is and that's spelled out in the retainer agreement, so that at the end of the process, the investigator knows here is what's being expected of him. In terms of other factors or issues that you want to consider in the retainer agreement, you want to look at whether or not you want recommendations at the end of the process, and if so, then that can be spelled out in the agreement as well. And a big one is the report. All right, what does that report look like? How many reports do you need? For federally regulated employers, we have there's the obligation under the Canada Labour Code to provide the parties with a copy of the report, and that copy that goes to them is heavily redacted in terms of no identifying information as far as other witnesses that were interviewed and participated in the process. So where you need multiple reports, again, that should be specified in the retainer agreement, because that's going to impact your cost at the end of the day. What you don't want is to have these expectations as far as what the investigator is going to do and the product that he's going to deliver, and then at the end of the process, and then that's not reflected in the retainer agreement. At the end of the process, these things are raised, and there's going to be an issue of cost and a potential. There's a room for disagreement there, or fertile ground for disagreement. So you want to bring as much certainty as you can to the process, and spelling out these expectations in the retainer agreement is the way to do it. The retainer agreement will also contain other information. So it'll spell out the rates for all of the professionals involved in conducting the investigation. So there may be a lead investigator who takes the lead in terms of the investigation interviews and drafting a report, but there may be a support team involved in terms of assembling that report and doing the administrative work and other support work. And so the cost for all of the professionals involved should be spelled out in the agreement. On the issue of cost, an experienced investigator should be able to give you a quote or an estimate in terms of what this process is going to cost based on the information that has been provided. And that gives you some confidence in terms of going through the process. You'll have a sense as far as what your budget is and what the this project is going to cost, and then the investigator will be in touch with you along the way if there's any material changes to that estimate. And we find it helpful to, and it's our practice to spell out in the agreement the fact that there will be regular communication between the parties, and we actually schedule a weekly call, so that way you're always aware in terms of what's happening with the investigation. If nothing happens that week, then the report back is pretty simple, that nothing happened this week, but here's what's coming up in the days ahead. And if there were interviews completed, then you're able to report on that progress. But it's very important to have a regular schedule of meetings or touch points where you can get the information that you need. And again, you're getting that at regular and predictable intervals. One of the questions that often comes up in investigations is the cost of them, and how do we manage that cost? And one of the ways to do that, one of the drivers of cost, is the time that it takes to conduct investigation interviews. And in terms of managing the cost, one of the things that employers can do is, to the extent that they're working with a union, they may be able to come to an agreement on putting a time limit in terms of how long interviews will take with various parties and witnesses. Now, that might be helpful from a practical perspective, and it is doable depending on the circumstances and the parties involved. However, I do want to make a note of caution here that the investigation, one of the ways that the investigation helps an employer is that it provides this mechanism and this process for the complainant and the respondent to tell their story about what's happened to them, or in terms of responding to the allegations that have been made against them. And you don't want to put a limit on that if it's going to interfere with someone's ability to tell their story, or someone's ability to put their best foot forward in terms of explaining and giving a response to certain allegations. So again, this is a strategy in terms of putting time limits on interviews, and that's something that can be done in conjunction with a union if you're in an environment where you have that relationship. But as I said, it's something to approach cautiously, because to the extent that you manage to save on cost, you may then end up upsetting the parties, or interfering with their ability to fully participate in that investigation, and there are negative consequences to that as well. Another driver of cost for investigations is how long it takes to review the relevant evidence. And to the extent that you need to move this process along quickly, you want to be cognizant of the information that the investigator is going to need to access, and do your part to facilitate that access. So if it's an investigation that's really highly document driven, and the investigator needs access to emails or maybe text messages that were exchanged by the parties, you can already start that prep work with your IT department to help organize this evidence and work with the investigator so that he can access what he needs. We just completed an investigation where we had to review numerous messages that two colleagues had exchanged to each other over the employer's Microsoft Teams account. So that was a situation where we worked closely with the client's IT department to recover these messages, and then to access them in a secure way, and ultimately rely on them for the purposes of our investigation. And it would end up being extremely key evidence as far as that investigation went. But the employer, there was a lot of urgency to this investigation, and the employer, really did a great job in terms of getting IT involved in an early stage and helping us to access that information quickly so that we could fulfill our mandate consistent with the expectations of the client. We talked about regular communication with the investigator and that being spelled out in the retainer agreement. And in terms of the practicalities of that, you want to make sure that the investigator is aware of who their contact is and who will be giving them instructions throughout the investigation. And that person then has the ability to set up these weekly calls and to get that timely information from the investigator. And you should have the confidence to and don't be shy about asking the investigator questions. If that person is experienced and they're confident and competent in doing their job, they'll let you know if there's a question that you've asked that is potentially on side or that maybe takes you into this area that the parties shouldn't go, especially if it's in the early stages of an investigation, and someone might be asking about how the evidence is shaking out and any conclusions that the investigator can make. But there's nothing wrong with, as I said, asking the question, and the investigator, if they're experienced, can let you know if that's appropriate or not. But certainly it's appropriate to ask about what's been done and what steps remain, discuss potential witnesses and what their value is to the investigation, and why it may or may not be important to meet with certain individuals. And when you receive a draft report from the investigator, certainly review it, and if there are any conclusions in there that you don't think are well-founded, you've reviewed the evidence that is summarized in the report, and you get to the conclusion, and you're not seeing how the investigator concluded that there's harassment here, then mention that and have the investigator go back and verify that that they have actually summarized all the relevant evidence, and that and that there isn't anything missing or something that he should have included in the report to further bolster those findings. Investigations, as they unfold, there is more and more evidence coming forward, and there may be more complainants that come forward with their own allegations of harassment. And it's important for the investigator to come to you and to get instructions from you as the situation evolves. So the benefit of having regular touch points with the investigator is that you're kept informed in terms of these developments, and you have an opportunity to go back and revisit the mandate if that's required. We are involved in an investigation for a school board, and there was one student that came forward with a complaint against the principal and others. And in the course of the investigation, another student came forward with overlapping complaints. And so it created the opportunity for us to speak with the board and to get instructions to expand our mandate to deal with both complaints, right? But that's an example of how these things unfold sometimes, and what should happen, as opposed to the investigator just running off and assuming that their mandate includes following up on all of these allegations that are brought to their attention. Another benefit of having regular touch points is that you should get timely notice of any red flags that come up during the investigation. So these are things like an uncooperative witness. We had an investigation that we started in August where it was a sexual harassment investigation, and the complainants, we'd reached out, initially scheduled an interview. They canceled those interviews at the last minute, and then it was taking several weeks to reschedule with them, which obviously caused a delay that the client wasn't expecting. So these are situations where you can bring that to the attention of the client right away. They can then follow up with these individuals and their respective union reps and help you, prod them to get their cooperation in a timely manner. other issues that come up is, someone goes on sick leave or someone's on vacation, and you need to meet with them before you can complete your investigation. You want to make sure that you're bringing these things to the attention of the client, because in the vast majority of cases, the client's sitting there wondering, well, when is, how much longer is this investigation going to take, and when are we going to be able to bring this process to a close? And if they're unaware that someone's on vacation and that you're waiting for someone to return from sick leave, there's that a disconnect there, and there's an explanation, for the delay in the investigation that the client is unaware of. So you want to make sure that you have those regular touch points, and that these important pieces of information and any red flags are brought to the attention of the employer as soon as possible. So in terms of concluding today's webinar, we want to leave you with three takeaways. And number one is making sure that you keep your investigation on track and manage the investigator right at the outset by clarifying his or her mandate. Make sure that that there's no confusion in terms of what it is that investigator is being retained to do. Make sure that in your retainer agreement, or in terms of just your the process that you put in place afterwards, that you have regular communication with the investigator. Our practice is to have a weekly meeting where we can send an update or have a brief phone call to let the client know what's happening in a given matter. But that's important that you have those regular touch points with the investigator, and don't be afraid to challenge the investigator, right? You keep them on track and keep them accountable by trusting your instincts and what you know about the file, and asking the questions that you need to ask, or challenging them on whatever aspect of the investigation it is that is troubling you, and that investigator should be able to give you the answers that you are looking for. So I'd like to open the floor now for any questions that you have. And there are a couple that have come through already. The question is, if there is a recent investigation report between the same two parties on similar complaints, would that be something that an external investigator should get in terms of information? So presumably the investigator that, if we deal with the current investigation, that investigation was undertaken because there are fresh complaints that came forward. So they may be similar in the sense of, the person's, complaining about harassment, but there's, just different conduct that supports their fresh complaint, as opposed to trying to, relitigate these complaints that happened to them in the past. And to the extent that this person has a harassment complaint against the same individual, and that was part of an investigation, I don't, on the face of the question, without any further details, it doesn't seem as though that would be a situation where the current investigator needs to, review that information. I would say there's no harm in letting the person know that, that there is a history here between these parties, and that that there have been previous investigations that have occurred, and so the fact of these previous investigations, I don't see that as an issue. However, if I was the investigator, I certainly wouldn't want to review that report or the documentation for those previous investigations simply because my sense is that it may prejudice how you approach these investigations, and maybe some of the preconceptions that you might have about the complainant or respondent as you start this fresh investigation. Another question that's come up is, I've experienced situations where the company became aware of a relationship between two individuals. It was not a reporting relationship initially, but there was a difference in the power imbalance so there was a power imbalance between the parties. The company decided to promote the lower level partner of this relationship, and that's what uncovered the situation. An investigation ensued, and we were aware of the situation in full. The position of the two was that we would be discriminating if the company did not continue with the promotion. What is the risk to the company? They opted to create an NDA between each of the individuals and the company. Was that the best way to resolve the investigation? So in terms of this situation, you want to go back to your workplace policies, and the policy, should indicate, should speak to the fact of, there's no prohibition on workplace relationships. However, where the individuals are in a reporting relationship, or if not, in a situation where there's a power imbalance, there are questions of consent that arise, and whether or not that person who's on the lower end of that power imbalance is actually able to provide consent to that relationship. And in those cases, that the relationship should be disclosed to the employer so that proper steps can be taken to manage that situation, right? And in this case, as you mentioned, the situation didn't come to light because of a positive disclosure. It came to light because one person was being promoted, and then through that hiring process, the issue came up. I would say, it's problematic when you catch these situations on the back end of the relationship, right? When things have already fallen apart, there's a breakup, and now you're dealing with the fallout of that, and one person may be questioning whether or not they should have been in the relationship, and this person was just using their power and influence over them to keep them in that relationship. You've got the other employees who may have been witnesses, and just feeling awkward throughout the process while this relationship was ongoing. And like I said, on the back end of the relationship, when things go sour, that's when individuals start making allegations, and they start saying to the employer, look, you're vicariously liable for these actions, and I suffered harm because you didn't take the appropriate steps, and and then there's claims of constructive dismissal, and claims of extraordinary damages that get thrown around. So it's difficult to say that whether or not, based on how this situation was uncovered, if it was dealt with in the right way. What I would say going forward, though, is that you want to start with your policies, make sure that the expectations are made clear in the policy, and then that way it gives you the ability to be proactive in terms of managing these situations going forward. And and what you're doing is really being focused on how do you maintain a healthy environment and make sure that that folks aren't using their influence to take advantage of others in the workplace. I'm happy to discuss that further. Again, there's a lot there to your question, so please do send me an email afterwards, and maybe we can schedule a 15-minute virtual coffee and unpack that issue for you in more detail. Sorry, the last part of the question was, would it have been better to... Was that the sorry? Yeah. So the question was whether or not that was the best way to resolve the situation. Yeah, I think I don't think there's anything more than I can add at this stage. We do have some more questions to get to, but as I said, please do send me an email. I'm happy to discuss it further. Another question that's come up is, what are the important steps to an investigation? So we have a whole webinar on best practices for an investigation, but essentially it can be broken down into the the fact finding, or the interview stage, where you've received a complaint, you're meeting with the complainant and to understand what their story is, and then meeting with the responding party and other witnesses to determine what happened. And then you've got then you have to wrestle with the evidence once you've collected it, and make oftentimes a credibility assessment and come to some conclusions as far as what happened, and make sure that you've got enough evidence to ground your conclusions. And then you have the written report that needs to be prepared to document the steps that you took during the investigation, summarize the evidence that's relevant to support your findings, and and then communicate, indicate your conclusions and recommend or recommendations in that report. So at a high level, that's what it is. But please do. You can find a recording of the best practices on our website. And if you are looking for any more resources, please do send me an email, and we'd be happy to share with you from the library of resources that we have. Mary has a question. She indicates that I've worked for an agent recently, and the pressure to hold hours down to repeat business has caused me to absorb many hours. Is there an industry standard for average hours per interview, per witness, respondent, or complainant? Any analysis, editing, and formatting? Okay, so there was a limit on the number of hours worked, but you still had to obviously put in the hours that were needed in terms of getting the job done. And you're wondering if there's any standard average for interviews with witnesses and parties, and then also standard hours for analyzing that evidence and then drafting and formatting a report. There are no industry hours per se. As you do the work, you get a sense in terms of how long something is going to take, and especially and that comes from the the nature of the allegations, right? If you're dealing with a 10-page document, you can get a sense pretty quickly that this 10-page document with 20 allegations is going to take a few meetings to get through with the complainant, as opposed to something that's much more straightforward. So it really just comes from experiencing, having a feel for what work is involved once you've reviewed the facts in a case. But just the reality is that allegations and each investigation is different, right? Like they're all over the map, and some are going to be more document driven. They might have only 3 or 4 allegations of harassment, but there's so many documents that are involved in terms of proving that. I had the sexual harassment investigation I did, which involved reviewing these messages that were exchanged over Microsoft Teams. That was literally only that investigation was 2 allegations, but the evidence, the text messages and the Teams messages that we had to review were voluminous, and then we had to meet with the parties a couple times to both get their evidence and have them respond right to these text messages and other evidence that we had collected. So unfortunately, there isn't as far as my experience goes, I can't really see an industry standard there. It really comes down to, as an investigator, having a good understanding for what's involved and what it's going to cost, and then being clear about that with the client, and then that should be spelled out in the retainer agreement, and you might even include a quote in the agreement, so that way there's no confusion, right, in terms of what you had indicated at the outset. Okay. Another question here is, I was told I was going to get an external investigator to conduct an external investigation on assault and discrimination. The employer misled me and gave me an internal HR person, but insisted that this internal HR person was external. The HR individual had no law background, but only had experience in conducting investigations. Whether that is internal or external, I'm not sure. My question is, what is the fallout for the employer for falsely providing an external investigator when in fact the investigator was not? There were other factors, but that also indicate he was not external. Okay. So what's the fallout for an employer in terms of using an internal investigator? One of the major mistakes that employers make when they conduct an investigation is that they don't implement a process that is free of bias or the appearance of bias, right? And what you're trying to do as an employer is to put in place a process that's going to help you get to the heart of what's occurred in the workplace. but you want to make sure you're implementing a fair process. Excuse me, where parties have the ability to be heard, where they can tell their story, where all of the relevant evidence is considered, and uh, the investigator, whether that's internal or external, um, wrestles with that evidence and gives a reasoned, a well-reasoned conclusion in terms of how they've characterized the behaviors in question. Where you have a serious allegation, as here as assault and discrimination, and you use an internal person to investigate that. On the other side, number one, you have to consider the fact that these are allegations that give rise to legal proceedings. So, this individual who allegedly experienced an assault and was subject to discrimination, they don't have to accept the conclusions of your investigation. They can go off and go to the police and file a criminal report, and there may be criminal charges that flow from that behavior. They can go to the Human Rights Tribunal. They can and file a claim of discrimination. They can just walk away from work and make a claim of constructive dismissal and ask for aggravated extraordinary damages because of the flawed investigation that was conducted. So I'm not saying that because this was done internally, it was flawed, right? Like, that's not what I'm saying at all. But where you have these serious allegations, including assault, you want to query whether or not having an internal person is the best person that's going to give confidence to both sides that they are being given a fair shake. And to the extent that, let's just say you use an internal person, and then on top of that, the investigation is not done well, then you've opened yourself up as the employer to these other claims that I mentioned, and the employee is going to have be able to seek a remedy in court, at a human rights tribunal, through the criminal justice system, and depending on what they've suffered or the harms that were inflicted through that process, we've certainly seen cases where extraordinary damages flowed from that. So in a case of Boucher and Walmart, Walmart conducted a negligent investigation. There were relevant witnesses there to observe the abusive conduct between the manager and this subordinate, and they did an investigation report that apparently, from what the evidence that came out in court, it wasn't clear whether they had met with relevant witnesses. And to the extent that they did, they certainly didn't rely on their evidence, because they made the conclusion that all of these allegations were unfounded. When the case went to trial, the plaintiff, the employee, was able to prove that these things happened, and there were witnesses that were able to support her version of events. So the investigation Walmart did was negligent, and there were extraordinary damages that were awarded against Walmart. Not exclusively because of the negligent investigation, but the harm that this employee suffered after making these serious complaints, and then being told that, we actually, these allegations are unfounded. We weren't able to verify anything that you reported to us, and by the way, we're going to performance manage you going forward because you're not following your manager's instructions. So. So Walmart didn't provide a safe working environment in that case, and as I said, there were damages that flowed from that. A question here is about whether or not my firm investigates fraud allegations. We specialize in misconduct, like harassment, sexual harassment, and other problematic behavior. We have done fraud investigations in the past. However, that's not our area of specialty. But if you're looking, depending on the situation, I'm happy to have a discussion with you about that situation. And if we're not able to assist, I can certainly point you in the right direction. Another question here is, for a complex investigation, is there case law in terms of what's the absolute max time limit on an investigation, or industry wide? Is there a general consensus that it should not exceed a year? There's no case law in terms of the absolute time limit on an investigation, but certainly the average timeline would be 2 to 4 months for an investigation. And again, it depends on the circumstances of the case, right? So when I say circumstances, we're looking at the number of individuals involved and to what extent individuals are available and willing to meet with you. I was retained by a school board back in May to conduct an investigation. We tried to meet with the complainant, and that complainant was working with an advocacy group. And for whatever reason, this individual was taking weeks to get back to us and to provide us with a date and to really, cooperate in terms of scheduling that meeting. So you get these delays, out of the blue that you can't anticipate. I anticipated that after being retained, we would have met with the complainant in pretty short order, and for that process to extend from May into June before we were able to sit down with the individual, it was troubling for me and troubling for the client, and unfortunately was a sign of things to come as far as the lack of cooperation there. So you sometimes can't predict what level of cooperation you're going to get, and certainly people go on sick leave during an investigation, witnesses go on vacation, and you just don't have folks accessible to you. But it's rare for an investigation to take, I would say, even more than 6 months. So the 1 year limit that is indicated, again, I don't know the scope of that investigation and how many people are involved and the number of respondents and to what extent folks are available, and if there's anything that explains that delay. But if things are chugging along in the normal course, that does seem like an extraordinarily long time. When we get an investigation, we have a workflow that we drop that investigation into, and we have and we monitor how things are going relative to that workflow, and are things happening on that anticipated schedule. So, and if it's not happening, then that's where we're having regular communications with the client to say, look, here's what we anticipated, here's what the other side is doing, and here's where we need your help, or here's how we're going to work around the situation, whatever the case might be, to move the investigation forward. But I can't think of an investigation that would take a year to complete. That's surprising. But I'm happy to again reach out. I'm happy to have a conversation with you, and maybe it can help you once I have some more specifics. Another question here is, what minimum education or training should you be looking for in a potential investigator? That's a great question, Ron. So you want to make sure that where employers get in problem and get into trouble is where they retain an investigator who doesn't have experience doing the type of investigation that's needed. So there was a case that I reviewed in a previous webinar on pitfalls that for employers to provide pitfalls for employers to avoid when doing an investigation. And one of the mistakes is that you hire someone who's done investigations, but in this case of home hardware, they had a sexual harassment complaint, and they hired an investigator who had no experience conducting a sexual harassment investigation, right? And that's that's a problem. Sometimes you're looking for someone who's got experience in a particular industry or context, right? So, for example, I have a lot of First Nation clients, and there are they're just unique circumstances to consider in that environment, and reporting relationships, and the way that folks interact with each other, and sometimes there's family histories there, right, that come into play and are part of the context. Like I said, because of the uniqueness of that environment, I would want someone who has experience, working with that particular client group to do that investigation. So you're looking for someone who has the right background. You don't. Again, depending on the nature of the allegations, you may want someone with legal experience, and this may be a situation that might lead to litigation, and so you definitely want it's helpful to have a lawyer involved and have someone approach that situation through that legal lens and make sure that you have a written report at the end of the day that's very thorough, that's airtight, that covers all of the relevant evidence, and then you then have a document that you can rely on to make whatever decisions need to be made. Maybe someone's going to lose their job over this. Maybe there is going to be potential criminal charges that flow because the situation involves fraud or the misappropriation of funds or sexual assault, and this might be a document that the police ultimately reference and may rely on. So again, depending on the circumstances of a case, you're going to look for someone who has the right background. But for complex situations, it's helpful to have someone who is who is a lawyer who understands evidence. In our case, we've litigated a number of cases before, so we understand how a case needs to be put in front of a court or put in front of an arbitrator, and the investigation report then reflects, right, that the fact that we've identified the right witnesses, we've referenced the evidence in a comprehensive way, we've reached conclusions that we can back up, and then if we're called as witnesses, that you can have confidence that the investigator, who's a lawyer and who's got background in litigation, if called as a witness, is going to be able to speak in a confident and persuasive manner at a hearing, as opposed to someone who may not be familiar, right, with that environment, and that might pose some difficulties for them. Okay, another question that's come in is, what are the typical rates and the typical length or timeline for an investigation? The timeline for an investigation, I would say average timeline is 2 to 4 months for an investigation, and again, a lot of it depends on the availability of the parties and obviously the complexity of the situation that you're dealing with. In terms of the cost for the investigation, I would say that it's really difficult to get one done for less than $10,000 when you factor in the completing the interviews and putting together all of the evidence and then drafting a report where everything is summarized and you've got the conclusions that you can rely on going forward. Like that process of going through all those interviews and putting everything together and then drafting the report, it's really difficult to do that. I would say for less than $10,000, unless it's the most straightforward of cases. And then in terms of the cost from there, it goes up just based on the complexity of the case, right, and the number of individuals involved. But at least I think that gives you a good baseline in terms of minimum cost and the average length of time that it takes to conduct the investigation. Okay, well, we've reached the end of our time today. I know we've had a lot of questions, and I really appreciate your enthusiasm and your participation at this event. So for those of you where I wasn't able to answer your questions in full, or if you've got a follow-up question, please do reach out to me. You can find me. I'm always on LinkedIn, so you can connect with me there. Or you've got my email address. It's on the screen. Please do shoot me an email, and I'd be happy to have a chat with you. And again, I made the offer to another individual. To the extent that you want to connect for a virtual coffee, I'm happy to do that as well. So thank you very much, everyone, for joining me today and for your participation. And look forward to seeing you at our upcoming events. Take care.